Hi, everyone. Welcome to episode 86 of the Immigration Lawyers Podcast. Thanks for tuning in today. I haven't done a solo episode in a while. It's been so many interviews going on and just busy with the practice and all the stuff that goes along with being an immigration attorney that I haven't been able to do this, even though I've had the notes to do this episode for like 2 months. And they just keep getting stuff added and added to them, so it's gotten a little complicated. Just to start, if you're listening on YouTube, on iTunes, or wherever you are, feel free to press like and subscribe and leave a 4-star or 5-star review, however many stars that website allows you to do. I'm on iTunes now, Spotify, YouTube, so feel free to go to those pages to watch. You can watch the program and get more information on Immigration Lawyers Podcast or immigrationlawyerstoolbox.com. There's a lot more information there. On the toolbox, I'm keep adding news, training material, and practice pointers, different things in the podcast themselves to help people get more involved. One thing I've been doing is, especially because the interviews are going long, is when I'm editing them, cutting out parts of it and putting them on little snippets on LinkedIn and YouTube and various places. So if you don't get a chance to listen to the whole thing, if there's some key points, takeaways that I want people to hear about, they can access those. So those are on the YouTube page. You can more easily find those, or if you're on my various social media channels. Also, if you're listening on Siri or iPhones, I don't have an iPhone, but if you could tell Siri, play Immigration Lawyers Podcast, and it'll come. You can say subscribe to Immigration Lawyers Podcast, and it'll do it. And the same thing for Google. Google's voice service to do that as well. And finally, for the intro, I wanted to thank a couple of new listeners, Aileen R., Haley R., Karamat Q, for listening and contacting me, and several other people. It was about a month ago, it was quoted in the New York Times, and the podcast was quoted in the New York Times, and that got a lot of attention. So that was fun, and I hope you read the article. Also, the interview I had with the former consular officer, Christopher Richardson, got a lot of attention, so that was a fun one, something to listen to. It's going to help your consular practice if you're handling consular processing kind of cases. So without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. So, the first thing I wanted to talk about was regarding consular processing. The National Visa Center does stuff on its own. It just changes the rules without announcing it to anybody. Two major things they've done is they're requiring tax transcripts now instead of the tax return itself, which kind of makes sense because, it's funny, right when that happened, I had some guy call me asking, could I just make up a tax return and send it to USCIS or the NVC so I looked like I'm making more money for the affidavit support requirement. And I'm like, no, I don't even know you're asking on the phone something illegal. Of course you can't do that. But I'm assuming that probably does happen. They'll catch people. So now they require you to get the tax transcript. It's not necessarily too complicated to get, which is you go to the IRS website, type in tax transcript IRS, and it goes to the page for the IRS website. And you could download your tax transcript. Now, logging in, the security procedure is kind of annoying, and sometimes it doesn't work, so you have to have it mailed to you. And I had a client who waited months and didn't get it, so they had to call and jump through a lot of hoops until they could finally get it. But you can get the IRS tax transcripts, and it's required by the National Visa Center now. Also, if you do file a tax return, or a client does, and they amend it afterwards, like I had one client who didn't list everything they should have, so I had told them to go amend their tax return and correct it. Once it was corrected, it wasn't reflected on the tax transcript. The tax transcript apparently only reflects the first filing with them, not the second or third one or any amendments that is you do with them for that year. So if that happens, in that case, we notified the embassy of the issue that there was no transcript. In that kind of case, we had sent it with tax returns, and then the embassy requested tax transcripts, and we got that, but I told them it doesn't reflect the amendment, but we gave the amendment and gave copies of pay stubs and everything to prove that there was income, but just a mistake, an error on the tax return, and it was approved. But that's something important to keep in mind. Also, with regards to the National Visa Center Consular Processing, the switch is happening for non-paper-based and online upload-based consular processing paperwork. And the difficulties that creates is they're very specific as to various features when you're uploading stuff. So the size of the document has to be less than 2 megabytes, which is really difficult. To have marriage certificates like from Iran that are like 15, 20 pages. And so, bringing that down to size creates a lot of additional work. Also, if the pages don't perfectly fit, if a side of like one part of it is somewhat cut off or somewhat crooked or it's sideways, they don't accept that. Everything has to be right side up and in the proper order that they feel is correct, or else they're not going to accept it. So that becomes a big headache because you have to keep going back and forth with them until they accept it. Now, when uploading those documents, try to separate the tax return for the W-2 and have a separate upload option for the W-2s itself. And finally, if you have something that doesn't exist or you don't have on hand, for example, police certificates. Some countries' police certificates are not accepted by the Department of State, so it's not required. But in National Visa Center website, it'll ask you to upload those. So what you can do is upload a page, a blank page that you type on it that says, this country doesn't need police reports or police certificates according to the visa reciprocity chart. Or with the option, when they ask for passport photos, you write, we'll bring the passport photos to the embassy. I mean, you could always scan that passport photo and upload it too, so they have it like that. But if you don't have it handy, or the person's just going to get it when they do the interview, you write a letter and say, please note that the passport photos are coming at the time of the embassy interview, so let the case go through, and that'll work. So that's some consular processing tips that are going to come in handy at a practical side. Also, I've been noticing that embassies are separating their fingerprinting and biometrics appointment from the actual appointment date. So I had a person, which country was it? Brazil, I believe. And they had to do an ASC, the biometric appointment separately, and then a day or two later go to the embassy appointment. They had to schedule both separately. Normally in the past, I think they would just go and do it both at the same time, but that's been separated. Other kind of consular processing things that have become a big headache, in particular with regards to India, is news I've been hearing about some officers there at the immigrant visa desk giving problems to people, and not just immigrant visa, but non-immigrant visa as well. For example, if they had a Hindu wedding, they're asked, did you do all the rituals that are required for the Hindu wedding? They won't just rely on the marriage certificate itself. They'll say, bring us pictures to show that you went and did all the rites and rituals that are required to have an Indian wedding in that sense, from that cultural group. And if you don't, they deny it, saying the marriage was not valid. So that's kind of nasty that they're doing that. Another thing, just if you've been dealing with Indian cases, it's been around a long time, is sometimes some Indian families don't name their child at the time they're born. So the birth certificate doesn't have their name on it. And that becomes a problem later because there's no name on it. Now, younger people, it's a little bit easier. You can get affidavits from their parents saying this is the name, or from the uncles and aunts, all that kind of stuff. But sometimes you have someone who's 70 or 80 years old, doesn't have any relatives that are born or aware of their birth at the time they testify. That becomes a big headache. It's a normal procedure in India to not necessarily have your name on the birth certificate. They may have their religious or cultural scenario where they go and name after the child's born, depending on the time they're born, and other theological kind of stuff. So it's interesting that issue exists, but just something to be mindful of. Now, moving on, I-751 removal of conditions. So this has always been a headache when you're dealing with removal of conditions, and it's only gotten worse with the delays. Thankfully, they've made it so that the receipt that they give you extends the residency for another, 18 months, acts as a green card. But that's always a problem because some employers don't understand the receipt acts as the green card extension, or people are traveling abroad and they want to come back on a plane and the airline says, I don't accept this paper as a green card, it doesn't make sense to me. Or they don't have the original I-751, they have a copy of it and the airline doesn't accept it. So that's a nightmare if that happens. Now, what's happening a lot now is they're taking a while to cash the checks, which is not much you can do about that. But also, the receipts don't come sometimes. So people file it, the check is cashed. And nowadays, they used to stamp the checks to have a receipt number on it. I've been getting a lot of checks stamped where it doesn't have the receipt number on the back of it. So what do? Well, you could go on the e-request system on USCIS.gov and request and send a contact saying you want a receipt. On the e-request, where it asks for a receipt number, you could type in LIN and then 00. Let me count how many zeros it's supposed to be. Whatever the receipt code that typical USCIS has, but it looks like 369. I might not be reading this right, but like 9 digits. LIN as in Lincoln, Indiana, Nora, 9 digits. Then to provide the A number and all the information for contact and requisite info, and then submit it, and you'll get a confirmation and probably get the I-797 notice in the mail, you know, for an 18-month extension after 7 or 10 days. Along with that, the biometrics notice. So I had a couple of 751 cases where it's been 6 months, 8 months where no biometrics notice have happened. So I actually did this process, and then all of a sudden in the mail we got a letter along, you know, different envelopes about the same day. Not only was it a new receipt that they resent us, so it's just, I'm like, okay, we have 2 receipts now, but they also got a notice that said because they had the biometric fingerprints still on file from the original adjustment of status, they don't need to do a new biometrics. And my worry had been that they sent a biometrics appointment notice that we didn't get, so the client might have missed it, and I don't want to go into denial for no reason because of missing a biometrics appointment or something like that. But that's the way they're handling it right now. They're not giving biometric notices and not letting you know the reason why until you hammer them on it. Now, what do you do if you want to contact USCIS to talk about this? They've changed the phone system and the phone tree to make it extremely difficult to get a hold of someone. And when you do, there's going to be a 20-30 minute wait. The first officer is not going to be able to help you much. You have to go to a second officer. There might be a 3 or 4 hour wait for that. So the system's just gone out of hand completely, especially now that they're cutting out InfoPass appointments online, so you have to call in to get it, and they're sometimes strict on that. So at the very least, you got to get a hold of someone. The code keeps changing, but essentially you dial 1 and then let the prompt go, then a 1 again, and then a 6, according to how the prompts go, and then maybe another 6, another 1. It changes, but 1161 and then some other stuff as they ask you questions is the way to go to be able to get to a live operator to tell them what your problems are, what your issues are, so hopefully they can help you out in that process. But hopefully that helps. The call tree situation is a mess, and just getting any sort of information. They keep trying to push you to the website, but the website's not helpful. The website eventually says call it in. So it's this nasty loop that's happening with the USCIS. And I mean, it seems like people are really just sitting in a room thinking, how can we make this process more difficult and lead more people to mistakenly get denials, or just make their life difficult. That seems like the mindset that's happening, unfortunately. If there are people from USCIS listening, I'm buzzing with people, I'm like, you get a lot of filing fees. You should have enough money to hire people or have some sort of system that doesn't make it completely miserable to try to just, you know, work together. Now, one problem I understand is when people are going pro se, they'll call USCIS for everything, especially when InfoPass appointments, they would go there just to ask, why is my case taking so long? And they wouldn't go check to see, well, processing times are what they are. As an attorney, I'm like a middleman where people call and complain about that to me and my clients, and I tell them it is what it is. But those who didn't hire attorneys probably, or even have had clients that didn't trust me and they go there, and then the USCIS tells them the same thing when they're there. So that hugely backlogs in-person appointments and phone calls, and I appreciate that issue does exist. But nonetheless, we need to have access to service, and people's lives are a matter. You know, there's issues of work permits. You don't want to be out of status or violating. There's all these kind of problems that eventually they have to work it out because it's service they're providing, and people are paying for this. Another weird issue that's happening is applicants are getting the names of their parents on their adjustment of status appointment notices. So someone's going to go for the green card interview. On the envelope, they'll have their parents' names, then their name or one of their parents, and then their name and their address. And it really throws up clients. Like, why is my parents' name on my parents' name on the adjustment of status interview appointment notice? That's just one of those things that are happening. Another issue that I've seen is for K1 fiance visas, there are times when you have to set up an interview appointment with the website, and K1s is just, when consular processing is such a mess because every embassy is doing it differently. Every month it seems like they're changing the procedure. It's never consistent, but sometimes you have to go into the US Visa Info website and schedule an appointment, and if that applicant had previously had a B1, for example, B1, B2 interview or some other type of non-immigrant visa interview, they're going to have this one confirmation number locked in there. And then when you go and pay the K1 fee, you have to get a new sort of case number for that, but the system internally won't update it. So I had a K1 out of Australia where I said it's a new case, set it up, came and paid the fee, then I looked at the receipt and it had like the case number, oh yeah, it was a DS-160 number for the previous B1, B2 that the client had applied for, you know, even though I updated and stuff. And I got worried because they said, you know, these payments are final, there's no refunds and stuff. I'm like, oh man, I'm going to lose out on this. So I just emailed them, and actually within a day, they just internally went and corrected the DS-160 case number on that receipt and then said, go ahead and print it out. So they could do that kind of stuff. You just got to email and communicate with them and hopefully have an embassy that's helpful. But that was able to fix, but just keep an eye on that beforehand because they were nice in that scenario, but you know, another embassy might say, okay, pay the fee again and then we'll correct it or something like that, and you'll be out that fee. Client might not want to pay it. So, you know, not everyone, I do those parts of the process myself too, as part of the service, instead of having clients log in themselves. So if you get stuck with that, it's bad. You want to try to avoid those kind of fees, additional stuff that you might be hit with. Another thing that a colleague of mine told me was interesting is sometimes when you have to file a case on a deadline, like you have an extension of status, I-539, or you're filing, change of status to some sort of work visa like an L1, and you need to file while the previous status is valid, and you send the package in, you're missing a document, or the check is wrong amount, and they return it. A colleague of mine said she did it a couple of times where she resends the application, apologizes, and says, please, could you still give us the, priority date or the receive date of the previous application, so it'll still be within the time allotted for filing an extension or adjustment or change of status. And she's been successful with that. Now, some of these applications, for example, extension of status, if you have a D1-2, it says if there's a dire need or some sort of explanation of why this happened, they'll still accept it. But for them to go back and put the receipt date at an earlier date because of the return is something interesting. And these kind of issues do happen no matter who the attorney is. It's just part of immigration law is errors like this happening. So if it does happen, this might be a thing to do. Just notify them, ask them, say, please, could you let us get the receive date that was originally used, or originally when you received the application, before you return it for that error. That's something important to look at. Moving on, the E2 treaty trader, or maybe even E1 treaty trader, treaty investor visa is a neat one. I have a love-hate relationship with it too, because I like L1s because they already have businesses going, the applicants do, or the petitioner, beneficiary, all this kind of stuff. So they're very sophisticated business clients that work with you to do it. A lot of times when I do E's, it's people that want to just dabble in business or their first business and stuff, and it requires a lot more hand-holding, which is okay, but it creates a lot of problems down the line because they're not familiar with business, having a business plan, and the chance of success is like 50-50 or maybe less than that, just because of the lack of business experience. So it gets frustrating. And some things I've seen is clients might get frustrated that their business is not working, and they might want to change status or get a work permit and just work regularly, and they'll think like you could just fix it up, like, okay, just come and we'll just get you H1B like that, like it's going to happen. It's not, or O1 or something like that. And they get frustrated with you. So it's important, maybe add in your contract for E2s and E1s, mostly E2s, to say you're not responsible for the success of the business, you only focus on the immigrant visa or the non-immigrant visa. The business is up to you, or not responsible for that. It seems kind of dumb really to have to include that in there, and it's not, you don't have to do that, but it's just something to put out there. You're not responsible for the success of the business. Your client comes to you, they say they're investing a good amount of money, they have a business plan, they're really set on being successful, and you say, okay, we'll get you the visa. That's all I'm doing is help you convey this information to the consulate so they'll approve it. But after that, it's on you. So it's not if you get frustrated with me that I can't fix the situation and get a work permit when it's just not possible. So that was an annoying thing that did happen. So I want to put it out there. Plus, another colleague of mine had this one issue where the investor started a business here, going successful. They're so successful, they want to invest and start and buy other kinds of businesses and grow. But the other businesses that would come, that they want to get into, or maybe come under E2, weren't in the original business plan. So then it becomes a little troublesome. Are we shifting the business so much? For example, if they have a restaurant and all of a sudden they want to invest even more money than the original restaurant was for to do some sort of side business in the music industry, it's so outside the initial E2 business plan that you might need to file an amendment, which is expensive and unreliable and has issues. So when you are creating a business plan for your E2, have a section in there of growth into general areas. So example, if you're doing a restaurant, say I'm in hospitality. So if the restaurant wants to open up, a bar, it's close. If it wants to go into opening up a hotel or buying a hotel, that's hospitality too, or services, additional services. So it's a little bit wider. It gives you some leeway to go into other areas without having to file an amendment if there is some vision or the people investors have experience in other areas and they might be dabbling in those other areas. To avoid having to redo an E at the consulate or filing an amendment, having it out there is good. So keep in mind when you're reading their business plans to include that kind of stuff in there. Another important note that I've seen a lot of attorneys that I've seen many practitioners don't know, and it took me a while to get. A friend of mine taught me this, and it took me a while to understand how to do it. But when we have clients coming from overseas and they need to do an L1 or E2, they're going to need a federal employment ID number. Now, because they don't have social security numbers, it's difficult for them to get it. Many times they don't have someone in the U.S. that can help them get it, so they don't have a person here. So how do you get that? Traditionally, people would like fax stuff over and stuff, and it'll take a while, and there might be a deadline. They can't wait that long, especially if they're going to do like change of status in the U.S. You could go to the IRS website and request a federal or federal EIN, and the way you do that is, as an attorney, I could be a third party and use my social security number just for the purposes of getting the EIN number, and that's it. My purposes there as a third party are restricted to just that purpose. And you fill out the website, there's an option for third party to fill it out, and then you get the EIN number and your duties are over, but the client then has their EIN. So that's something, a practice tip that's going to be very helpful for those who are going to be working on E1s, E2s, L1s, and types of business cases where investors are coming here or business people are coming here and they don't have a social security number to get that EIN for the business, which is mandatory for registering it for USCIS purposes. One issue, and it kind of goes along with these kind of business cases, if you're doing premium processing, you're seeing the headaches that are happening. The amount of denials have gone on astronomically. People are getting RFEs. Frankly, RFEs have gone astronomically, but people are getting RFEs, they respond, and then they get the same RFE back as if no one read it. Not even a denial, just another RFE. Or they're going outside the 15 days. And so it's a big mess going on. California Service Center, other service center for human processing. And one colleague said they looked into it and talked to some people. It looks like they're understaffed or short-staffed, and that's why this process is happening. Potentially they were told by one person, this is just hearsay, but that the officers that were handling their case are out of town or on vacation, and another officer is reviewing it, but they don't think it's appropriate for them to finish the adjudication of the officer, so just resend the RFE to give him more time. And this really messes up with the 15-day timeline that people have. Also, it's a reason for get your money back, but request your money back for premium processing is really difficult with them, even though it's that's what this the contract you're signing says they're supposed to return it. So those are kind of the headaches that are going on with premium processing right now. Now, another thing I've been seeing that's been problematic for a lot of business cases, I-129 non-immigrant visas, is the I-94. So when you have an I-94 approved, whether it's an H or an L, the I-94 receipt will give you the approval notice, will give you the time that you have on there. If you go to the embassy, if they give you more visa time on the visa than the I-94 or just the approval notice time will be, or if CBP gives you more time on the I-94, their time is invalid. You have to go back to what the basic approval notice for that visa category and status says, and you're limited to that. Just because CBP stamps more times not paying attention doesn't mean it remains valid. So that's something whenever your clients come or periodically check on their I-94, so they'll travel without telling you, go online and see what it says and check to make sure, have a thing on your calendar that reminds you of when the L1 stay is going to be ending maybe 3 months beforehand. So you contact the client so they don't think that the time that CBP gave them their stamp on their passport is the correct date. Now there's nunc-pro-tunc and stuff like that you do try to correct it, or you could maybe go to CBP and talk with them or something like that, but it's not a reliable thing to do, so just keep an eye on it. These kind of errors happen, and at the end of the day, the government has the ability to just say, no, we're not going to fix it, or we're not going to do non-pro-tunc, and you're out of luck, and all of a sudden the person is out of status, accumulate unlawful presence days, they can have a 3-year bar. It's like a domino effect of misery that comes, so that's something very important to be looking at. Now, just as experience increases when you practice, especially in light of President Trump, the difficulties of student visas have increased a lot because of the new rule where they begin accumulating unlawful presence as soon as they do a violation of their F1 or J1 or M1 status, regardless of the fact that it was duration of status, and historically, until there was a finding of some violation or NTA was issued, unlawful status wouldn't have been accumulated. So this created a nightmare. There's lawsuits going on this, and hopefully it'll be fixed, but you frequently see students make mistakes. So one thing you got to be really diligent on is every time a student comes in your office to talk with you, you have to request all their I-20s and read them all, the first and the second page, the work history pages, the dates, which countries listed, every little thing you can to analyze the I-20 to make sure there are no errors, because the students won't understand it and that mistake will come on you. So whether they were here in high school or college or whatever, as F1 visa holders in particular, you have to study their I-20s in detail. I didn't have a habit previously of always collecting them because, if you go to college here and drop out and you do a marriage adjustment case, it doesn't really matter your college time here, you're out of status, but it's something important to do just to make sure the information is on this correct so there's no other types of mistakes or violations that could happen. especially, if they want to do a certain change of status kind of thing, not necessarily marriage, U.S. citizen marriage adjustment status. Maybe it's an LPR adjustment of status, LPR spouse, which doesn't have the exemptions that INA 245 exemptions that the other categories do, that the immediate relative category has. So that's a big thing I've been doing in my practice, is really studying the I-20s and going through the history more than before. And you realize clients lose their I-20s, they don't know, they don't update it, they don't tell the school when they found a job. That happens a lot. It's really nasty. They don't get EADs when they're supposed to. They didn't even realize they're supposed to get EAD, and they just start working. You want to get that, especially if they come to you, towards the end of school and they're about to graduate and start working. You gotta say, hey, you gotta go and see this, request the paperwork so you can file an EAD, and don't start working until you get that EAD, because it's going to be problematic. Now, EADs might take more than 90 days. You're not allowed to be out of work for 90 days. How do you deal with that issue? I don't know. Luckily, I haven't had that, but it's something that can happen, and it's problematic nowadays. But reading the I-20, make sure the student has the EAD or has filed the EAD properly. You don't have to file the EAD request within, I think, 30 days of the school issuing the signed notice for it. It has to be done before graduation. There's a lot of nuances, and because of the new regulation that Trump put on there, I went back and read INA, I think 214.2F or whatever that regulation for student visas are, and it's long. Read it, and read it multiple times to really get the details of it. For example, you could do CPT. There's a commenter saying that if you do CPT, it takes away from your OPT time. But that's only if you do CPT for a year or more, and the CPT is full-time. So if they're doing part-time CPT, less than 20 hours, that doesn't affect the OPT. So it's just like little nuances like that. You gotta read the wording, but it should be okay if you do like that. So again, really study student visas. It's a hot new issue because of the way the regulations are interpreted now, until these lawsuits go through and hopefully return it to the previous duration of status system. But as it is right now, it's a minefield, so definitely good to know about that stuff. With regard to L visas, they've got a lot more strict, and the typical situation where they question whether someone's a manager or executive has gone to the next level. I'm getting them asking about breaking down the duties, the percentage of duties of immediate subordinates, and all this kind of stuff. So already, an L is hundreds and hundreds of pages. They're just adding so much more time and stuff to make it really just so expensive to be able to hire a decent attorney to help you with that. It's kind of crazy. They're also challenging, I've seen cases where they challenge whether a person could use an independent contractor to show that they have lower level employees doing stuff, which is ridiculous because they've had AEO decisions, precedent decisions that says you can use independent contractors, and these have been approved for years. So they just do what they want to do. It's really scary and really unacceptable that they're doing these. I think going AEO PO route at this point is just a mistake. On L1s where they're being ridiculous in their decisions, you have to sue, and I wish I'd done that more in the past where they were just really hassling us. But definitely either get involved in lawsuits yourself. And I have an interview with an attorney, Jonathan Wasden, that's coming up after this. I'm going to be publishing it, and he just does employment-based lawsuits, a lot of H-1B stuff, especially because it's H-1B season right now. But with regards to the L's, to really create some standards here, so and just to hold their feet to the fire. Now going to our favorite subject, the travel ban, something I talk about a lot. Representative or some congressman or Senator Holland, I think it was, regularly asked the Department of State for a question and answers regarding what's going on travel ban. It was just released a few days ago. It's something to look up. It's on the Immigration Lawyers Toolbox in the news part of it, but it really breaks down what's going on with the Department of State, how many travel ban-based visas are issued, and how many denials, and how they process and all that kind of stuff. One interesting note is I have marriage, immediate relative-based cases, and when they go to their embassy interview after processing and everything like that, they do get the initial refusal, but their case is kind of in this administrative processing limbo, and it's fine. But I've seen one or two cases where people did K-1 visas and they were just denied outright. So they do distinguish between immediate relatives and non-immigrant K-1s, and they'll just deny the K-1 outright. So you waited 8 months, get the I-129F approved, and do consular processing, and go there, and it's not going to be on hold and just wishing for the best. It might get straight denied. So if you have clients that have deep enough relationship where they could just get married, that would be the better way to go rather than doing the K-1. I generally try to avoid the K-1s anyways, but if client wants to do that but can't get married, that may be a better way to go. Now, I've been trying to do an interview with this one attorney who does lawsuits with regards to travel ban, and she's been successful doing APA lawsuits for the travel ban and winning the cases and getting the immigrant visas issued. So it's possible. She's so busy doing these that I can't even finalize the time to meet with her or do our interview. But just for people listening, people have sued because of the travel ban and have been successful, and immigrant visas have been issued. So if you have clients waiting a lot and they have the money and the riskiness, or could accept the risk of going through a federal lawsuit, that is possible, because a lot of clients are just so frustrated they'll do anything at this point. So filing a lawsuit may be the way to go under the APA. Just generally talking about lawsuits, in December 2018, there's been such an increase that there are 37 new federal civil immigration naturalization lawsuits, up 26% over the last 6 months. So the delays have gotten so much in that people are suing constantly. And with regards to, I talked about Attorney Jonathan Wasden, who has H-1B lawsuits. They're overturning these bad decisions. So what the norm is that people sue because of decisions so ridiculous, and USCIS just gives in and approves it. So the case doesn't go to trial, and there's no public record of how ridiculous it is, and having a federal judge admonish them for what they're doing. And we'll talk more about that with Jonathan Wasden in the next interview that's coming up. But that's something to know. And with regards to delays, AILA has been talking about this. They published this big report that went around the news about how long cases are taking more than ever. And ZLA, the Asylum Office in Anaheim in California, they said as of January 2019, they have 35,950 pending cases. Now, Asylum has seen an astronomical rise in filings in the last 5 years, but almost 36,000 cases in backlog is just kind of crazy. Now, going to just the ridiculousness of how the system and instructions and guidance is set up, both regards to the instructions for forms and the adjudicator's field manual that trains USCIS employees. Someone on another listserv brought this up, and I just had to share it because it's so crazy. So on Form I-130 and I-130A, there are instructions that say if the answer to this question is not there, or none, or not applicable, you write NA. Now I don't put anything on it, leave it blank, and sometimes maybe I should put something on there in case an officer writes something in. It looks like we added it, but I always leave it blank. Or maybe it's better just do a dash so it fills up the box and no one can write in there, but you show that there's nothing there. But if you look in the Adjudicator's Field Manual, section 21.2, it says, quote, "Be aware of the use of the term NA, not applicable," even though the instructions for those forms say to put NA. It's, quote, "is commonly a ploy used to try to conceal relevant information. Therefore, it should be generally not be accepted as an acceptable answer." So it's just so ridiculous. They tell us to write NA, and then in the Adjudicator's Field Manual it says if someone does that, that's a sign of fraud. Be careful. So this is what we're dealing with. It's just mind-blowing how ridiculous it is. Now, U visas. I don't do U visas, but I read this one case. I saw this one case came out in the Third Circuit that under U visa, a child can age out. So if you have a case pending and the child's going to be close to aging out, the CISPA situation doesn't apply to them. Also, another colleague had posted they got a denial because for the U visa, they asked for a copy of every single page of the passport, and they didn't send a copy of the inside page of the cover. So when you open up the thick page, that's the cover of the passport, and then there's immediately the back side of the front page, or the front cover, you have to copy that side as well. I don't do use, so it's not something I'm paying attention to, but she got denied for not doing that. So if you do use, make sure to include every single page. Don't even miss one, or else you can get a denial for no reason. Now, some practice pointers on the EAD, especially if you're filing for adjustment status and you get an EAD with Advance Parole with it. Always check the EAD to make sure the notice about having, I think it's I-512 or something like that, parole is there, because you don't want your client to leave with an EAD thinking it's automatically an advance parole, and the permission of advance parole is not listed there. Also, if someone has an EAD previously based on a student visa or something like that, the USCIS number is not necessarily the alien number. So what you see is a lot of students have a USCIS number that is not an alien number. It's not something you can use to look up a case or even use that as the alien number. Usually, I think in those kind of cases it has a 1 or something at the beginning. Those are not alien numbers. And so that's something to know when you're filing these kind of cases or trying to find documents based on that number. Another reminder, this is something that comes up a lot. I've talked about it before, but I keep talking with practitioners who don't know this. For an immediate relative case, if someone is here on the visa waiver, they're allowed to adjust status even if they came on ESTA or visa waiver. That's filing for adjustment status is not an issue. You can't do change of status or extension of status or other people, non-immediate relatives, can't file for adjustment of status. But for parents of U.S. citizens, spouses of U.S. citizens, and minor children, they're allowed to adjust status either before the 90-day mark or afterwards. Now, if they file at all and the period that's for the visa waiver ends, ICE still has jurisdiction to pick them up and take them away. But as a policy, USCIS doesn't refer to them unless they have some sort of criminal issue or problems that come up, so they can be removed and picked up or removed. But they can adjust status, and it's not USCIS policy to have this information given to ICE for being picked up. And a note is, if you're in the Ninth Circuit and you file the case within 90 days, within the 90 days arrival, the applicant does get permission to go to a judge in immigration court to have a hearing before they're removed from the country. So it's not an automatic removal that's typical of the visa waiver program. And that leads to the next thing, which is there's a lot of discussion of this 90-day rule. If you get married or file for adjustment or something like that within 90 days, it's problematic. It's a sign of immigrant intent, all this kind of stuff. There's a federal court case that says in the Ninth Circuit, if you file within the 90 days, you get the right to go to see an immigration judge. So if federal court has said you can get married and file for adjustment within 90 days and still see an immigration court and not get into the fact of maybe there's immigrant intent, maybe there's not, all that kind of stuff, then that means it's okay to file within 90 days if the people didn't have immigrant intent when they first came in. And that happens a lot. People come here on vacation and people get married on spur, and they either want to stay here or they wanted to leave. But the thing is, now that they're married, next time they want to come in, CBP may not allow them in and give them, expedited removal, and then all of a sudden they may have a ban. So it's so messy and risky that you just have to stay and adjust. And that happens frequently, where I have clients who, on a whim, get married, come to me to talk about how green card process is, and I say, listen, if you leave the country now that you're married and you try to come back in just for vacation while the case is pending, CBP might not let you in. They might just put you on a plane, hold you for a day, and then put you on a plane and send you back. Hopefully give you voluntary withdrawal, or maybe worse, you get expedited removal, which is going to be a nightmare. You might need a 601 waiver, all this kind of stuff. And that reality and the chance of that happening is so scary that they say, you know what, I'm going to quit my job back home. I have a house I'm paying rent on, or mortgage, and I'll keep paying it, but I don't want to deal with expedited removal. Or, frankly, when you just get married, you may have to travel. You might want to go back and forth all the time. You don't want to be away from your spouse. Now, one thing I'm seeing is, the answer immigration lawyers always give to someone who has an I-130 pending is don't apply for a tourist visa because they won't let you in, or if you try to enter while the case is pending, that they're going to deny you an entry. Now, I always tell clients not to do it, and everyone I know always says that, but most of the time, many times, my clients don't listen to me and just come and travel back and forth until they have their immigrant visa interview, and it's been fine. So it's not like, it's very low chance actually that'll be a problem, as long as they have a life and they talk to the officer, let them know, and they're not trying to conceal anything. But CBP does allow people to come and go, but there is that risk, and because that risk exists and the potential consequences are so harsh that it's better not to even bother traveling and just have the U.S. resident spouse travel overseas to meet that their significant other. Now, there's been a lot of increased fraud going on towards clients or people interested in immigration. One thing that's happening is there's these people that are sending, paperwork to people in Africa and Asia saying, we're going to find you a job in the U.S. and get you an H-1B visa. Fill out all this paperwork, and they make these fake State Department or USCIS forms on their own that collects all their information. Then they say, pay me $1,000 and we'll get you EB2, EB3, H-1B. They pay it and nothing happens. Or they'll say, we're the go-between with the lawyer and do this. So I had a person contact me and say, yeah, the agent told me that you're handling my case, so what's going on? I'm like, I don't even know who you are. What are you talking about? So he sent me this paper and this contact information that some guy off Facebook connected with them, sent this fake paperwork that has State Department stuff on there to fill out, had his information, and then the guy paid him, and the contract they signed said your lawyer is John Khosravi, JUK Law. I was like, oh my God, you just been scammed, man. Like, I don't even know this. Like, why'd you pay them? Why'd you deal with me directly and all that kind of stuff? So this is happening a lot. I've been seeing other attorneys mention this as well. So, I mean, how are you going to get the word out to people? But it's unfortunate. Another thing that you should be mindful of if you have a practice is, I had, every once in a while I research my name, my firm name, to see what's going on. I did it once for this. I typed in, JQK Law Firm, and to see what kind of results come. And I saw, my website is jqklaw.com, and then after that, there was another website popped up that said jqklaws.com with an S. I was like, what the heck is that? So I clicked on it. It was a mirror of my website, but the email and the phone number were changed. It was info@jqklaws. My email, it was info@jqklaws.com, and to get their email. And then they also made their own phone number, but everything else is the same. And if you dug within the website, because they didn't change it, they only changed the major pages, but the sub-websites had my contact. But people were falling for this phishing scam and sending them paperwork, and that's another thing. People contact me saying, oh, we went to your website, this and that. I'm like, that's not me. So it was a big headache correcting that, contacting Google to say they did copyright violation. I do that a couple times. And then I have to find who was hosting that website, spend days and days arguing with them and the way they wanted the code to be written for me to, just ridiculous kind of stupid stuff to study to figure out how to do it. I forgot now how it is. But for them to finally remove that website that was, doing fraud on people and misrepresenting my website and my name, which could have been potentially very problematic for me. So try digging around and maybe add an S to the end of your, if you're abclawsfirm.com or firms they would have written or something like that, to dig in deep to see if this kind of fraud exists, because that was pretty nasty that they're doing this to people, and it can be a problem for you. There have been a lot of issues with regards to citizenship and passports that have been happening in the news, and it's very interesting how immigration is the cutting edge of everything that's happening. So there was one case where this woman apparently was the child of an ambassador, so when they're here, they're not, was born here as well, but when you're an ambassador, that doesn't count because you have immune diplomatic stuff going on. But she argued that her father lost his diplomatic immunity or diplomatic rights like a month before, so she was born as a citizen here, as a natural born citizen. And to get her passport, I think she sued once and got it. She left, fortunately joined ISIS, got crazy and all this kind of stuff, was trying to come back in. The State Department just canceled her passport, stuck outside. Now, screw that person is going to go join ISIS, but we have rule of law here. You can't just upend and cut people off like that, because that sets a tone that the State Department could do silly things like that. If the person comes here, they should be able to go to jail and then get a hearing in court, for treason and all that kind of stuff, but also be allowed to come in to figure out what the situation is with their passport. So it's very interesting that they did that. State Department is doing some very risky stuff. Now, another thing they did is there was a gay couple. One spouse was a U.S. citizen, one spouse was Israeli. They got a woman in Canada to birth their child, and they had twins. And so one of the twins had the genes of the U.S. citizen father, got a passport. The other one didn't, had the genes of the foreign national spouse, was still going to go in, it seems like the I-130 process, and they weren't given a passport. And there was all these debates and stuff, and eventually lawsuits happened. It was big news that the U.S. accepted, courts forced the embassy to issue the passport and citizenship for that other child. And it was interesting when I read the court cases they cited. There's this Ninth Circuit case that says, for example, if I'm married to a U.S. citizen and I'm a foreign national, I cheat on my wife and another woman gets pregnant, because I'm married to a U.S. citizen, that illegitimate, if you will, child becomes a citizen as well, because the stepmom's still a mom. And it was interesting, that could happen. But when you look at same-sex marriage and having a surrogate mother and how that affects citizenship, it's amazing how these immigration issues touch upon every little thing in life, and it's so important. Finally, with regards to this, there was a transgender person who was actually in the military that wanted to change their passport and from male to female, and the State Department wasn't willing to do it and made all these arguments, and the court did a good job chopping up their arguments, really putting them in their place. For example, the arguments the government is making, it's a security matter to have male or female, but the courts say, no, this is just a recent phenomenon that they added male or female. It wasn't even mandatory before. And then for immigration practitioners that deal with the FAM, the Foreign Affairs Manual, this is very sweet. Here they say, I noted in my last order, and will note again here, that the term policy is a bit of a misnomer. The policy which the department claims requires it to issue passports only marked M for male or F for female is really a collection of rules pertaining to gender contained within the Foreign Affairs Manual. These rules do not explicitly state that the department cannot issue a passport containing an alternative gender marking, and also do not contemplate the existence of a gender other than male or female. Rather, they simply explain how the department deals with different issues related to gender on passport applications. So they go on more other stuff, but they really just say this isn't God's word. These aren't the commandments. This is just policy manual that they have, but it's not the final word the way the FAM is. So federal courts could poke holes and change it. So that becomes really important. Now, one thing is even though I've been practicing this long and I've read the same court case and rules so many times, I'm still every time going to say something for certainty to the client. I get paranoid. I do research again. One of them was if someone's here is overstayed and they're going to adjust through marriage, U.S. citizen, and they want to travel once to get advanced parole, is that going to trigger the 3 or 10 year bar once they leave because they've overstayed? The answer is no. And I know for sure because of the matter of Arrabelly, which said that, and I've had so many clients go and leave and come back without a problem. But I just went online and checked that again. And I was checking these websites for law firms. I was checking the Alvo.com, and this is after the Arrabelly decision. And so many lawyers, the big name lawyers, were like, no, if you leave your 3 or 10 year bar, you're screwed, you're out. And it's amazing how much bad information is out there. So it's really important. Like the 90-day, the advance parole doesn't trigger the 3 or 10 year bar if you get it beforehand, you travel with it. Now, if someone enters and tries to enter to be paroled back in, and they have criminal history or other kind of admissibility issues, that could be a problem. But the 3 or 10 year bar doesn't trigger. I think it's like a legal fiction that you're still inside at the border and you haven't left. That's how they look at it. So it doesn't trigger the 3 or 10 year bar. But that's really important to know because sometimes clients have emergency issues and they might have overstayed 10 years, but they have advanced parole now, and a family member gets deathly sick and they have to see him. Don't give them bad information that they can't go visit that person. Ideally, they wouldn't. They would just stay here until they adjust status. But, these are important times in people's lives. And if they have the opportunity to do that and the risk is very low, you shouldn't shut them down just because of, lack of reading the rules and not knowing the rules, especially for a case like matter of Arrabelly, which is so important for any immigration practice. It's one of those pivotal cases. And so many people have, deferred action DACA cases have been able to adjust status, getting advanced parole, traveling, coming back, and then I-130, I-4A filing. So it's definitely something that happens all the time. It's the root law of the land right now. Don't discount it. Another important issue that I wanted to talk about is with regards to signing, immigration forms. Do they have to be original signatures, or could they be scanned copies and all that kind of stuff? And I was doing some reading on this, and it's kind of circular into how they go in through this, but there was a memorandum that came out, a policy memorandum of USCIS on February 15th, 2018. It says, a signature is valid even if the original signature is later photocopied, scanned, faxed, or similarly reproduced. Regardless of how it is transmitted to USCIS, the copy must be of an original document containing a handwritten ink signature unless regulations or the form instructions state otherwise. So essentially they're saying they accept copies as long as it's like a handwritten signature with ink and it's a copy of that, unless the forms say otherwise. Now, most of the forms don't say anything, but I'd be hesitant to send in photocopies of it anyways because I'd be afraid of what they do. But there's a footnote to what I just read from the policy manual. It says footnote 3, the regulations do not require that a requester submit an original or wedding signature on petition, application, or other request to USCIS, see 8 CFR section 103.2b4. So actually the footnote, it says that there's no requirement that it be, an original wet ink signature. However, as I was saying a second earlier, I wouldn't really trust that in. So when you go to section 8 CFR 103.2b4, it says supporting documents, original or photocopied documents which are required to support any benefit request must be submitted in accordance with the form instructions. So the citation they have there doesn't cite to anything meaningful, so it's probably an incorrect citation that they give, but that's the policy memorandum. But when I take the next level, most of these forms, the people are there and you can send it to you, but sometimes you need a G28 on the fly. Or you're doing an I-130, I-130A for a marriage petition, and on the I-130A, it says the applicant or beneficiary doesn't have to sign it if they're overseas. However, now on the first page, it asks, is there a G28 on file? Is there a practitioner helping you? And you mark the G28 box, and then you have to submit a G28. So should you have the foreign applicant mail you an original G28? So they're trying to help you by not having them sign the I-130 and have them mail it there, but now they got to sign a G28. That's problematic. So I did one thing. I went and just read the instructions for Form G28. I'm surprised I hadn't read it sooner, but it says validity of signatures in the instructions for Form G28. For Form G28, USCIS will consider a photocopied, faxed, or scanned copy of the original handwritten signature valid for filing purposes. The photocopy, fax, or scan must be the original document containing the handwritten ink signature. So if you need G28 signed, I don't know about the rest. There are some that say specifically, for example, Form I-765 EAD work permit, you can submit a copy, but there's a couple more that say you can submit a photocopy, but the rest I would go ink. But for the G28, you can submit a photocopy of one, which is great. That's good to know. Another issue that's been popping up a lot, I've been seeing a lot of practitioners misunderstand this, and I did a whole podcast on this. I'll either link to it or something like that. It was a Ninth Circuit Court case about it. But if someone's in a period of authorized stay because they filed for an extension of status, a change of status, asylum status, and the case is still pending and a decision has happened, they're in a period of authorized stay, which means they can stay and hang out and wait for a decision, but it's not status. Status is something different and limited to people who have green cards, who have a valid non-immigrant visa, who have asylum status, and very few other options there. So once that status ends, they can't then, adjust status. For example, if the asylum case, if someone is here on a tourist visa for 6 months, on the 5th month they file for asylum, and the extension of the B2, B1, B2 994 expires, and then they marry a green card holder and file for adjustment of status, they don't have status to be able to adjust. Now, most lawyers, it seems, most adjudicators, most people don't know that, and still cases go through. But as a practitioner, you got to be careful of taking a case like that, because you got to know it's not status. And the same comes for if you're using INA 245K to adjust status for an employment-based case. INA 245K says you can be out of status for 180 days, but the status ends on the date that your I-94 expires. So if you had like a H-1B, it expires, but you had filed an extension of status beforehand, and the extension was pending for 200 days, on the 199th day, if you file for adjustment of status, you can't adjust status because you've been out 180 days. Just because you had a holdover from the extension pending that went to 200 days or held you over, that doesn't count as status time. So you're not subject to the 3-year bar for being here that long because you're covered. The period of authorized stay prevents you from accumulating. That's the primary purpose of the period of authorized stay, is to prevent the accumulation of unlawful presence time for the 3 or 10 year bar. But you're not in status, and you can't use that to adjust status, extend status, change status. That exists unless you're going through INA 245K within 180 days and all that kind of stuff. Going back to INA 245K, I read something on a new member division list for ALO, which is really important. Now, when you're doing an adjustment of status based on INA 245A, you could adjust if you're admitted or paroled in the United States. But if you're going to use the INA 245K exception, you can only use it if you've been admitted into the United States, not if you've been paroled. And it's so nuanced when you read these statutes of how it looks. So it's if you're paroled into the United States, it doesn't work. You can't use INA 245K. It's only if you're admitted. And there's more stuff I'll talk about in another podcast or something like that, but when you really dig deep and read how the statute's worded, for example, when you're doing a 3 or 10 year bar, the 3 year bar is if you've been here for 180 days. But if you're 180 days here and you haven't been issued an NTA, and you leave as a problem. If you've been here 180 days, let's say, and then an NTA is issued, a 3 year bar won't apply for you, but the 1 year will, because the wording of how the 3 year and 10 year bar is written. Or there's another thing I studied a lot is there's a requirement where if you get your green card through marriage, and then you divorce from the spouse and get married again, and you want to petition for the new spouse, if this is done within 5 years, you have the higher standard of proving that the marriage is real. And so you have to file an exemption waiver, all this kind of stuff for that. Now, what if you got your green card through marriage, but it's because you're married to an employment-based category, and you adjust the status or got an immigrant visa based on being spouse of an EB2 or EB3. So is that getting a green card through marriage? Maybe not. You're getting marriage to a U.S. citizen or lawful permanent resident? I don't think so. So what happened is I was worried about this in a case because the person, was a spouse of an EB beneficiary, got just status, they got divorced, remarried, want to file a petition. I'm like, well, does this mean that within the 5 years they got married, is that going to be an issue? And I was rereading the regulation, and I saw that it talks about that issue applies if you got your green card as a spouse of a lawful permanent U.S. citizen, but that person got their green card as a spouse of a priority worker, and they instantly became a green card holder along with the spouse, not the spouse getting and giving it to them in that sense. So I don't think it applies, but you got to really read the statute and how it's worded to be mindful of this kind of stuff. Now, with regards to the medical requirement for adjusting a status, you have to do a panel physician, or if you're a USCIS, a civil surgeon, get vaccines and all that. And especially if you're in the U.S., you don't have to get a chest X-ray unless you have a false positive or test positive for TB in the initial test. Then they have you do a chest X-ray. And in most countries of the world, it's the same. They only do the chest X-ray unless there's a positive signal that you have TB, and they have to do the chest X-ray. But I had a client that we went through I-130 processing, immigrant visas coming up, they get the interview scheduled, and they call me and say, you know what, we just got pregnant. I'm like, oh, congratulations, so wonderful, recently pregnant. So they go to the panel physician, and the panel physician does the test for TB, it's negative, and then they want to do a X-ray. And then like, well, this woman's pregnant, you don't really want to X-ray someone when they're pregnant, who knows what happens. And so I'm like, okay, they call me up, say, stop that, let's just see what's going on. Go look into it. Apparently, everyone has to do the X-ray no matter what, if it has to happen. Even if they're pregnant. The U.S. specifically says pregnant women have to do it too. They could delay the medical part, go to the interview and then just go in administrative processing until they submit it. But they have to give the chest X-ray. Now, this was kind of weird for me because I'm used to them only requiring a chest X-ray only if there's a positive signal on the initial test. So I had to do research into it, and I realized, according to CDC, there's like 10 or 12 countries where the rate of TB is high enough than the what they consider is appropriate, so that everyone in that country has to do it. So I think China's one, maybe Brazil is one. And so, typically my clients don't have to do a chest X-ray at all unless they show positive, but some countries it's mandatory. So then that becomes a thing of like, if I'm going to have a client from one of these countries in marriage case, they're a young couple and they're going to do immigrant visa processing, and the female spouse is the foreign national, throw in there, and this goes to the next level of service, hey, don't get pregnant or something like that, because in your country you might have to do a chest X-ray. Now they're going to put extra covering and stuff, so it's probably going to be okay for the fetus, but that may be required, so it's up to you. Speak with your physician how it is, but don't get pregnant until you do the medical exam. You come in because you may be required to do an X-ray and you might not want to do that. So it's these crazy kind of things that pop up that you don't expect. Now, one thing that does pop with TB is when people get that, especially in the 80s and 90s, they'll get a vaccine for TB and they show a false positive that they have it, and they'll mandatory to get chest X-rays. So that's another thing when it's people from Asia, Eastern Europe, and Latin America, most of the world, really except America, and you'll know if they have it, if they have like a vaccine mark, a circle on their left arm or right arm from when the vaccine was taken. It leaves like a dimple that stays forever. And you'll see a lot of foreign nationals have that. If they have that, they're probably going to test positive, so they have to then do an X-ray. So just tell them beforehand that this may be an issue. You might have to do a chest X-ray. So if it potentially has complications with regards to pregnancy or other kind of stuff, be mindful that that may happen because they have this X-ray as mandatory. I know a couple more things that I wanted to mention. One is a colleague had said that they submitted documents to the embassy, and the embassy came back saying, we're requiring the translation document be certified by a court translator. I was like, that's kind of ridiculous. The translation requirements are pretty easy. I was looking at the U.S. and it didn't say that. Our USCIS is pretty open. Just needs a certificate of translation. But he had that issue. I haven't got that issue. People come back to me. But that may be the direction they're going in, is to get more strict. Or if it does happen, maybe challenge them. But let me know if that's happening. Because if it happens regularly, that's something that the U.S. lays on with the AILA should know. And we should really just push the U.S. on that issue. Now, one thing I talked about, I had a discussion interview with attorney Nicholas Morales in a previous podcast I just posted. I'm sorry, not with Nicholas Morales, with author Skylar Anderson of a book called The Right Way, a novel about immigration and court and all that kind of stuff. And discussed about free work, and I posted on social media that snippet of whether it's appropriate for a student to like go and work for free, or frankly do free consultations. And I got a response from another attorney, which is a thoughtful response. They say, we do it, we'll do certain cases for free consultations. And with regards to someone who's coming up, either a student or a new lawyer, any way you can get experience, the better. And that may be the case. Not nothing's 100% that work for free is not good. But I've come to the conclusion for myself that it's not good to be work free, because looking back, I did a lot of internships when I was in law school, and when I graduated, I worked for so many different places for free. And I thought in my mind it's good because it pads my resume, looks like I've been doing all this kind of stuff, but it didn't really make a difference for padding my resume. But more important than that, what I saw is places that I worked for free, which is most of the places, because they weren't paying me, they didn't care enough to mentor me or give me work. And I'd find large swaths, maybe days, where I was just surfing the internet, trying to find something to do, or reading stuff, files just to learn, or trying to listen in on their phone calls so I could learn what's going on. But because they weren't paying me, they didn't really care. But when they were paying me, they had expectations from me. And although people having responsibility expectations like somewhat of a burden, in life, the more people expect from you, the more harder you'll work, the more you'll learn. So that way they will look at my work and they will give me work because they know they're paying for me, and so they're losing money if they don't do that. So that's one of those things. It's a backwards thing. It's not about the money that you're getting paid to support stuff, which as a law student with expensive law students now, it's important to get something. But it forces the employer to pay attention because they're losing money if they don't pay attention. And so that's one of the factors I really think you should go for work that's paid. If it's free, you got to see how diligent the employer is going to be and really talk to them about that and say, listen, I'm going to work for free, but that doesn't mean I'm going to waste my time. If I'm here, I want you to give me real work and give me mentorship and be here, and I'll do my best and I'll provide that. But it's got to be a two-way street. So that's something to talk about. finally, when I was talking to Christopher Richardson, the former consular officer, he mentioned WikiLeaks, and I'm like, oh, WikiLeaks was a thing where they published a lot of cables from the Department of State, and now just straight up, these are not classified, non-classified cables that I'm sorting, so I didn't do anything wrong or anything like that. But I know the WikiLeaks stuff was mostly about the controversial kind of internal Department of State talk about foreign countries and leaders and info they got. But now, like, wait a minute, like, that'd be interesting. It must be non-immigrant visa kind of consular processing kind of stuff that we deal with in there. So I started reading into it. It wasn't much, unfortunately, but there was some that came up when I was going through it. I just thought it'd be interesting to read and end with. For example, the U.S. Embassy in Istanbul had notes about the kind of people that were coming in there requesting B visa cases and stuff that came up that they had little stories on. So I'll read them. So they had one in Istanbul. It said it came for a tourist visa. It said also last month, a Turkish female claiming to be a film producer applied. She stated that she was going to meet the vice president of Paramount Pictures in Hollywood. When questioned how, without speaking English, she could carry a conversation with the American studio executive, the applicant replied that Paramount was providing an interpreter. She then was asked how she planned to take care of her 2 young children who she planned to take with her to the United States. Without missing a beat, the applicant rejoined that the interpreter would pull double duty as babysitter as well. Not surprisingly, when contacted by phone, Paramount's vice president denied any knowledge of an appointment with the applicant. A check of her documents revealed the applicant to be a part of a fraud ring passing purloined paperwork. I'm not sure what purloined means, but it is what it is. But the embassy went out of the way to contact the vice president at Paramount to double check this. So one is the story that this woman was pulling was the fraud was amazing. And secondly, the consular officer took the time to call and find the information and phone number to connect with the vice president at Paramount. And was able to connect with their sector with them too. They believed that this was a consular official. So that kind of crazy stuff happened. Another was this: a woman from the hinterlands recently applied. I'm not sure what hinterlands is, but recently applied to visit her son to studying in the United States. The son's application indicated that he had departed Turkey only the week before. And in marked contrast to his provincial's other ragged appearance, his visa photo showed him stylishly garbed in a dark maroon jacket and coordinated silk tie. So the mom said she was going there and looked like a hot mess, and the son looked very sophisticated, so it didn't make sense. The mystery deepened when an informant, and so there are informants, when an informant subsequently accused the young man of having used fake documents to obtain his visa. Months later, a group of men claiming to be business owners as well as another would-be student on the same day were found to have submitted applications written in the same hand. Despite appearing for their interviews in street clothes, each of these gentlemen, like the student with the fake documents, presented photos depicting them nattily attired. I'm not sure why his officer's using this kind of adjectives for writing, but it is what it is. A fraud investigation produced a total of 11 applicants with matching business information, phone numbers, and handwriting on their applications. 7 of these shared an even closer connection: the same body. A magnifying glass inspection of the visa photos revealed that their heads had been photoshopped onto the identical jacket and tie-clad torso. The apparel's color had been altered one to the next, perhaps to suit each applicant's fancy. So it was putting their heads on another person, changing the clothes so they have this sophisticated clothing and body, but they would come to the interview dressed up like garbage. So that really set it off. That's interesting that they thought about that. Now there's another one from Frankfurt, and one thing I learned from former consular officer Chris Richardson is that these embassies frequently do these reviews to see what kind of visas getting approved, what not, what are the things that are common. For example, if they overstay and that, they kind of whatever kind of reviews what they do them. And here in Frankfurt, they conducted a validation study. It's called a validation study of in 2007 of Iranian B1, B2 travelers, so Iranians who requested tourist visas in 2007 in Frankfurt. It said of the 288 applicants who traveled to the United States, 19 or 6.6 of them claimed asylum, adjusted status, or overstayed. For the vast majority who returned from the U.S. without incident, standard indicators such as age, family ties, and marital status were largely accurate predictors of good travel. 2 categories of higher overstay risks emerged: travelers over the age of 60 with immediate family in the United States, those are adjusting price status as immediate relatives, and travelers under the age of 35 with promising professional career potentials. They probably claimed asylum or something like that. So those are the things they'll look at as a Frankfurter, the mindset. They do these kind of studies to figure out who has problems or not. And finally, one thing again, Consular Officer Chris Richardson, former Consular Officer, told me is every time there's turnaround the embassy, a new manager comes in every 2 years, they try to change something up to make the policies reflect them and to show they're working hard. And one thing that happened is e-visa policy changed in Spain last week, or in London, they slightly changed their direct filing 5130 marriage case filings, requiring like bona fides, whereas before they didn't want it, or this kind of stuff. So it's something mindful. There's turnover, and that's kind of a bad thing sometimes because they make it more strict, but it's kind of a good thing sometimes because maybe you have a more understanding manager or more hardworking manager that comes there is willing to work with applicants if they sense that a case has problems or something like that, or work with their line officers to figure stuff out, whereas the previous one didn't. So if you have experiences with one embassy or consulate that's not good, 2 years later that could change. So it's not consistent that they're going to stay bad because these officers rotate frequently. So I guess I'll leave it with that. I'm going to chop up a lot of this episode, and I did it in a certain way. I talked about it for this purpose as well. So you have tidbits of information going out to help people. Feel free to email me, info@jqklaw.com, if you have any comments or questions. Visit Immigration Lawyers Toolbox. Subscribe to the podcast, like it on YouTube. I'm on Spotify now too, so listen to it there. Anything to get this population, this group going, to share this kind of information. I'm hopefully going to get some CLE provider credit, and the good thing about California CLE provider credit is it reciprocates for a lot of different states, so the programs I'm putting out will be able to give CLE credit if you sign up. I have a lot of this stuff coming out. I'll be talking about in the future. It's been a long time I've been talking about doing it, but I'm finally wrapping things up to get it started, hopefully sooner rather than later. I think that's about it, but thanks for joining the Immigration Lawyers Podcast. Until next time, have a good one.